Let's check with Judicial Education Center, which describes the essentials for contract in law as offer. One of the parties made a promise to do or refrain from doing something or some specified action in the future. Examination board, doctors, service providers, good providers, nobody is immune for it when you're offering something and expecting something in return. It will lay down the foundation for a contract. Consideration. Something of value was promised in exchange for the specified action or non-action. This can take the form of a significant expenditure of money or effort, a promise to perform some service, an agreement not to do something, or reliance on the promise. Consideration is the value that induces the parties to enter the contract. It appears that Judge Jackson made her own law. She doesn't abide by the law, nobody else does, so why the hell should she? Plus, on her website, she duly noted that her uncle was so proud of her because she was the first one to graduate from high school. And then she became an attorney, then she became a judge. And now there she was, with the noose around my neck hanging me from the nearest tree. The existence of consideration distinguishes a contract from gift. A gift is a voluntary and gratuitous transfer of property from one person to another without something of value promised in return. So her court order was not a gift to me, nor was the exam given to me by the National Board for Certified Counselors. It's costing me all money, and what am I getting in return? Human fecal matter. Failure to follow through on a promise to make a gift is not enforceable as a breach of contract because there is no consideration for the promise. None of the judges, including the NBCC as an examination authority, stated that, oh, we gave whatever Mr. Butt received as a gift, so they can't use that for a defense. Please, attorneys, Department of Law, take note. Acceptance. The offer was accepted unambiguously. Acceptance may be expressed through words, deeds, or performance as called for in the contract. Generally, the acceptance must mirror the terms of the offer. If not, the acceptance is viewed as a rejection and counteroffer. Mutuality is where the contracting parties had a meeting of the minds regarding the agreement. This means the parties understood and agreed to the basic substance and terms of the contract. So now you all know what contract means. NBCC had a contract with me to provide me with a competent exam and mark accordingly with competence. They did neither. When the complaining party provides proof that all these elements occurred, that party meets its burden of making a prima facie case that a contract existed. I did much more. And the person who prepared all those documents is a qualified member of the Bar Council of Ireland, the Bar of California, and the Bar of the state of Georgia. Highly acclaimed, highly competent. Ask her peers. Judge Jackson said there is no contract, even though the defendant agreed in print that there was a contract in existence. I wonder if there is a God, because if this is what God created in His reflection, all religions, all faiths go down the gutter. Because it looks neither pretty nor good for human consumption or for the consumption of anybody. If you're having any problem understanding that, I cannot make it any simpler. You go to the shop, it says 10 cents for a lollipop. You give 10 cents, you get a lollipop. If the lollipop stinks of poo, it's not fit for human consumption. Hence, the vendor, the seller broke the contract. Because in principle, and with jurisprudence, the lollipop sold to the child has to be fit for human consumption because that's what the child expected. Meeting of minds between two reasonable people states a sweet, sugary content attached to a stick which is tasty and enjoyed by a child. Not a piece of dried up poop, because that would be a breach of contract. Tell that to, I was just going to say Dr. Jackson. She needs a doctor. She may need doctors of differing kinds because she said, oh, common sense is subjective. Yes, madam, it is. The way you applied it subjectively, you showed your ignorance, your incompetence, your stupidity, and also that you are unfit to serve as a jurist. Each and every comment you made during that brief hearing was prejudicial, was stupid, was ignorant, and all your proceeding had absolutely nothing to do with law. Inclusive of Mr. Joseph Hall Wiesman kissing your ass from here to high heaven when he said he despises coming to this court. But as it is you, your majesty, it's an honor to appear in front of you while his teeth were chattering, visible to all and sundry in the courthouse. Nervous as hell, breaking sweat, and it looked like he was having a nervous breakdown or a heart attack. Take note, Mr. Joseph Hall Wiesman. Sue me, because you threatened to do so. When my so-called attorney said, and they told me, straight to my face, in normal circumstances, I will treat him like a piece of shit. But Mr. Butt, you have neither the resources, nor any future income. So we won't be representing you. These are attorneys who consider themselves high on ethical list. This is just the beginning. Close your eyes and try to live what I have stated thus far. And try to remain sane. Have faith. Hopefully have food on your table and be able to go to sleep at night. Because in a bed full of cacti with a noose around your neck, it is impossible to go to sleep. So let's move forward. For a defending party, i.e. the National Board for Certified Counselors, aided and abetted by Mr. Joseph Hall Wiesman of Hawkins, Parnell, Thaxton and Young, to challenge the existence of the contract defies all logic, because they did not provide a shred of evidence undermining one or more elements. I'll refer you to the documents. They are there on griftersnet.com. Look at their defense. Look at the court order. 2014, 2015. I stand corrected. 2015. DeKalb Superior Court. Judge as Ha F. Jackson. her court order, supplemented by the wisdom of Judges Phipps, Dillard, Peterson. The law as stated and applied holds all with knowledge or being witness to a criminal offense as an accessory to the crime. Please do not argue with me. It is stated clearly in every law journal, manual, legal script. Even an a-hole understands that. So please do not argue with me. Many highly capable and intelligent people in Europe tried and came out losers. I do possess a certain level of intellect. Please come after me. When gauged with measure for intellect, intelligence, and or decency, the US of A has been repeatedly found wanting. Repeatedly. A pedophile priest standing there giving our sermon while their congregation, parents turned a blind eye to their children who were screaming blue murder and saying, "We do not want to go near Father Murphy." They came to me for counseling 40 years thereafter. And then they wished for their parents to come down, and some of them did. And it turned out Father Murphy had done the same to the parents. So the parents went into a state of denial. So in this hellhole of South, the good people of Georgia, the good people of South, and the great people of this great nation of the US of A, who are you going for therapy? Who are you going to for mental health intervention? Father Murphy screwed you, is screwing you. And if precedent is to be followed, the generations to come. And you, the good people, pray tell me, what exactly is it that you are doing? Pray tell me, because I appear to know nothing. Okay, let's refer to history. Or if you're illiterate, then no worries. You're in good company. And just try and find one who actually has literacy skills and not a US PhD. When people ask why I was invited to a postdoctoral course when I do not possess a PhD, it was repeatedly acknowledged in UK and Ireland that I was wasting my time because no one had the intellect or the wherewithal or the expertise about my field of expertise. The subject matter. Mental health and psychological assessment of male going through family breakdown. At least they were honest enough. And they knew me. I was quite well known on radio, TV, and in social circles and academic circles. Here I'm a nobody because everybody's smarter than I. A US PhD is a worthless sheet of toilet paper. Actually worse, because you can actually wipe your ass with a sheet of toilet paper. Most of the PhDs I came across cannot string a paragraph of assessment together, and they're dealing with human beings. Code of ethics. Who gives a crap? So say the lawyers, so say the judges, so say the doctors, so says, the mental health specialists, who are bound by honor, so says National Board for Certified Counselors, and their attorneys. Have you ever seen such filth? So let's come back to the Canadian geese. What do? Wherever they fly, wherever they land, they leave nothing but black, stinking, fecal matter behind. They never signed up to no code of ethics. they did not have to submit a certificate of moral competence. Attorneys do. And then they proceed to go on poop on all and sundry because they can. Who's going to hold them accountable? Justice Alito? Hey, he was welcome in the Vatican. He loves this. He loves that. He loves being an ass. Every time he opens his mouth, verbal poop comes out. And then there's the Queen, Clarence Thomas. Oh my God, what a Christmas cake. Puddings all around. They don't believe in code of ethics. Every person who took the bar exam to become a member of the state bar, they could not do so without submission of a certificate of moral competence, and upon passing their exams, they become signatories to code of ethics. Supreme Court, take notice! What a bunch of shagging assholes! Sovereign immunity. Oh, ask the state of Georgia. They enjoy sovereign immunity. Not so when a crime has been committed. So says the US Supreme Court. They made the ruling against the dental board because they did not have supervision. So every licensing board in the United States, till that period in time, was not covered by sovereign immunity. They had none. So let's get back to facts.